Hello everyone, welcome to Oliveboard. I am Anshul, your CAIIB mentor, and in this series we are discussing all the important sections of your acts given in your BRBL paper. We have already covered the acts in the module A and module B. Today we'll be discussing the important sections of the schemes and acts given in the module C. So module C has certain important acts like the SURFACE Act is there, the debt recovery tribunals, we have the MSMED Act, RBI integrated ombudsman scheme. Not all the sections and clauses are important, only those which are critical from the exam point of view, those we are going to discuss today. So let us start. First act given in our module C or the scheme is the integrated ombudsman scheme of 2021. So this scheme, it has integrated the three previous separate ombudsman schemes which were there. The ombudsman scheme, the banking ombudsman scheme of 2006, the ombudsman scheme for NBFCs 2018, and the ombudsman scheme for digital transactions 2019. Now, the clause 4 talks about the appointment and tenure of the ombudsman and the deputy ombudsman. Both are appointed by RBI. One or more of its officers RBI is going to appoint, and the tenure will be for a period not exceeding 3 years at a time. Then we have clause 10, which talks about the grounds for non-maintainability of the complaints. These complaints will not be dealt by the ombudsman. A commercial judgment of the regulated entity, dispute between a vendor and the regulated entity, grievances not directly addressed to the ombudsman, general grievances against the management, dispute involving the employee-employer relationship, services not within the regulatory purview of RBI, right? So these complaints become non-maintainable and RBI is not going to deal with them. Then the procedure for filing a complaint is given in clause 11. Complaint can be filed either online through the portal or even through the electronic or physical mode to the CRPC. Then clause 15 talks about the award. Award will include the compensation, which will be either the consequential loss or the compensation which is decided rupees 20 lakhs, whichever is lower, right? Plus not exceeding 1 lakh for the mental anguish, loss of time, and other things which are suffered by the complainant. Then the rejection of complaint is given in clause 16 and appeal before the appellate authority in clause 17. The regulated entity also can file an appeal to the appellate authority, the executive director in charge of the department which is administering the scheme. But if the award is passed because of non furnishing of information by the bank, that is ex parte, then the bank, the regulated entity, cannot make an appeal to the appellate authority. These are the important clauses of our integrated ombudsman scheme. Then next we have the MSMED Act. First in this act, we have the definitions of the micro, small and medium enterprises, which are the revised definition given in 2020 are also important according to the investment and turnover, right? Now we have the section 3. So under this act, advisory committee is formed and then the National Board for Micro, Small and Medium Enterprises is also formed under section 3, right? The responsibility, what are the functions, everything, functions like affecting the promotion and development of the micro, small, and medium enterprises, recommendations on matters referred by the central government, how the funds can be better utilized. Similarly, advisory committee also for the five officers of the central government, they also examine the matters referred by the board to them, right? So central government gives matters to be examined to the board, board gives these matters to the advisory committee. Then section 7 talks about the classification of the enterprises according to the definitions. Then the liability of the buyer to make payment is given in section 15. The date from which the rate of interest is applicable. That is also important and it is given in section 16. So, where any supplier supplies any goods or renders any services to the buyer will make the payment on or before the date agreed upon between them, right? Or maximum, this date should not be more than 45 days. Then the date from which the interest rate will be applicable. If the payment is not done within the time period agreed between the buyer and the supplier, then the buyer will be liable to pay compound interest. This compound interest will be at monthly rest and it will be three times the bank rate as notified by RBI. Then section 21 talks about the composition of the micro small enterprises facilitation council. Section 21, Director of Industries will be here. One or more office bearers or representatives of associations of micro small industry. Then representatives of banks and financial institutions, people having special knowledge in the field of industry, finance, or law. This will be the composition. And finally, section 27, which talks about the penalty. Penalty for the non disclosure. All right. So, section 27, whoever intentionally contravenes or attempts to contravene any of the provisions, then in the first conviction, fine can be extended to rupees 1000. Then, second or subsequent conviction, fine which shall not be less than 1000 rupees but can be extended to rupees 10,000. All right? Okay. So this is there in the MSMED Act. Then we have the Bankers Books Evidence Act. This talks about wherever any evidence is to be presented, we need not present the original document. Copies are also accepted. Okay. So section 2A talks about the conditions of a printout. We have the certified copy if maintained in the electronic form and in the mechanical form, then a printout can be taken. So, what are the provisions? Section 2A, when the books of the banks are not handwritten and copies are taken by the way of printout. So, a certificate by the principal accountant or the manager that the printout is a true copy. Then the certificate by the person in charge of computer system also, that safeguards have been adopted so that no third party breach has been made. The manner in which the data is transferred, the mode of identification of the device, safeguards to prevent and detect any tampering with the system. These are the conditions. Then section 5 talks about where the officer of bank is not compellable to produce the books. So in any proceeding where the bank is not a party, no officer of the bank shall be compellable to produce any banker's books, the contents of which can be proved by the production of certified copy. Also, the requirement of filing the original document will be insisted only when the documents itself are disputed. It should not be easy for any party to dispute the documents. This is given in the section 5. Then section 6 talks about the inspection of books by order of the court or judge on application of any party to a legal proceeding. The judge may order that the party be at liberty to inspect and take copies of any entries in the banker's books. But this should be for the purpose of the proceedings. Any person. And the application of costs, which is given in the section 7. All right. So, cost of any application to the court for the purpose of this act, the cost of anything done again under the order of the court for the purpose of the act will be at the discretion of the court itself. The court may further order such costs to be paid by the bank to the party if they have been incurred any consequence of any fault or improper delay on the part of the bank. right? So the cost will be paid by the bank. Then we have the Legal Services Authorities Act, under which the Lok Adalats are established, the 1987 Act. So the section 19 talks about the organization, particularly section 19(1) talks about the organization. So we have the Lok Adalats organized by the state authority, district authority, or the Supreme Court Legal Services Committee, or even the High Court Legal Service Committee, or Taluk. Right? So at the state, Taluk level, district level, the Lok Adalats can be established. Then the composition will be serving or retired judicial officers, other persons as specified by the authorities, experiences and qualifications will be decided. Okay, then we have section 20, which talks about the cognizance of cases by the Lok Adalat. This is given in section 20. So, criminal nature cases will not be dealt by the Lok Adalat. Disputes where the parties they agree to refer, that can be taken to the Lok Adalat. Dispute where one of the parties makes an application to the court for referring the case to the Lok Adalat. Dispute where the court feels that it is appropriate to be taken cognizance. All right. So these cases will be dealt by the Lok Adalat. An award of the Lok Adalat is given in section 21. That is, the award of the Lok Adalat shall be deemed to be a decree of a civil court. Decree of a civil court. And in case of compromise or settlement arrived at by the Lok Adalat, the court fee paid in the case shall be refunded in the manner which is provided in the Court Fees Act of 1870. All right. Again, the Lok Adalat has all the powers, summoning and enforcing the attendance of any witness, discovery and production of any document, reception of evidence on affidavits, requisitioning any public record or document, or any other matter. The Lok Adalat has equal powers. Then we have the Consumer Protection Act, which is again an important act of 2019. Section 3 talks about the Central Consumer Protection Council. So, apart from the Central Consumer Protection Council, we also have the State and District Consumer Protection Council. These are the section 3, 4, and 5. The working and objectives are given here. The composition, the Central Council shall be an advisory council. The minister in charge of the Department of Consumer Affairs at the central government will be here. All right. Similarly, State Consumer Protection and District Consumer Protection Council. So, District Council is given in the section 8. Central Consumer Protection Authority. This is given in section 10. Authority established only at the central level, right? Obviously, established by the central government. The date from which the authority will come into force to regulate matters relating to violation of rights of the consumers, unfair trade practices, false or misleading advertisement. All of these will be dealt by the central authority. It also has an investigation wing. Okay. Then appeal is given in section 24. If any decision is passed by the authority and any person wants to make an appeal, so they can make an appeal to the National Commission. National Commission, right? So, any person aggrieved by the order passed by the central authority can make an appeal to the National Commission within a period of 30 days from when they had received the copy of the order. Then, appeal can also be made against the order of the District Commission, which is given in section 41. So, we have the District, State, and National Commission. All right. So, yes, where can we make an appeal? By an order passed against an order passed by the district commission, we can it will be dealt by the state commission. All right. Also, no appeal by a person is required to pay any amount in terms of an order of the district commission shall be entertained by the state commission unless the appellant has deposited 50% percent of the award determined by the district commission. This is in section 41. Then appeal to the national commission is given in section 51. Appeal can also be made if, let's say, any person is aggrieved by the order made by the state commission, then within 30 days they can prefer an appeal to the national commission. And finally, we have the National Consumer Disputes Redressal Commission, the organization of which is given in section 53, right? So again, central government is going to establish it. It will ordinarily function at the national capital center and perform its functions. These are the important sections of our Consumer Protection Act. And then we have the SURFACE Act. SURFACE Act, again very important, and so many provisions are there under the SURFACE Act. So first we have the section 3, which talks about the registration of the ARC, the Asset Reconstruction Company. So for the registration, they have to file an application to the RBI. It has to obtain certification of registration, and it has also to keep the own funds at the time of registration not less than 2 crore or whatever is decided by RBI. This is given in section 3. Then section 9 talks about the measures that can be taken for the reconstruction of assets, powers of RBI to call for audit and inspection. Now, RBI can give the registration certificate, they can reject the certificate, or they can also cancel the certification. So, after conducting the audit and inspection, they can cancel the registration as well. When under the reconstruction process, management is taken over by the ARC, then no compensation is paid to the directors for the loss of office. Whenever the process starts, automatically it is deemed that they have vacated their office and no compensation is paid. This is given in section 16 of the Act. The Act also talks about the formation of the central registry, right? Again, central government is going to establish it at a place decided by the central government for the registration of the charges, modification, satisfaction, then particulars of creation, modification, satisfaction of security interest. Also, any intangible assets, charges will be made effective with surcharge. This is given in section 20. Provisions that do not apply in certain cases are given in section 31, and offences by the companies are given in section 33. Wherever we are talking about the company, so section 30 talks about no court shall take cognizance of any offence punishable in relation to non-compliance other than the Surface Act. All right. And section 33 says that yes, offenses by the companies, wherever any company has committed an offense, so how the directors will be responsible, how the directors, if they prove that they were not involved, then can they be given any safety or security or not. So if a company and its officers commit any offense, both of them are punishable. They will have some statutory obligations. All right. Penal provisions are applicable to all the category of borrowers. If, let's say, a person, they can prove that the offense was committed without their knowledge, or they had exercised due diligence to prevent the commission of such offense, in that case that person will not be punishable. Otherwise, the director or officer shall be deemed to be guilty for the offenses along with the company as well. These are the important sections of the SURFACE Act. And then we have the debt recovery, the DRT. How the DRTs are established, the Recovery of Debts and Bankruptcy Act of 1993. We know the constitutional validity, how it was challenged in the Delhi High Court, then what decision was taken by the Supreme Court in favor of the act. So, establishment of tribunals is given in the section 3. right? So the central government is empowered to establish one or more tribunal, which will be known as the DRT. They will exercise jurisdiction, powers, and authority. The area in which the tribunal will work, the presiding officers of the tribunal, similarly DRAT, their chairpersons and the qualification, everything is decided by the central government. The qualifications, terms, and conditions of service of the presiding officers of DRT are given in section 6A. So, a person is qualified for the appointment as the presiding officer if she or he has been or they're qualified to be a district judge. District judge. Similarly, the time period until they attain the age of 65 years or 5 years tenure. Similarly, for the chairperson of the appellate tribunal is given in the section 10. They have been or are qualified to be a judge of a high court. They have also been a member of the Indian legal service or and held a post in the grade for at least 3 years, or they have held the position of the presiding officer for at least 3 years. Powers of the chairperson of the appellate tribunal, other than hearing of the appeals, they also have powers to inspect the presiding officer. If found to be involved in any mismanagement or incapacity, the chairperson can also conduct the inspection and, in writing, submit this to the central government. Then, appeal to the tribunal under section 19 is given. If any person is aggrieved by the actions taken by the bank, they can make an appeal to the DRT. Appeal can also be made to the appellate tribunal against the award passed by the DRT. This is in section 20. So, section 19 and section 20 talks about the appeal. All right. So, these are the important provisions and sections of our Recovery of Debts and Bankruptcy Act, which is also in short known as the Debt Recovery Tribunal Act. All right. So that is all. We have covered all the important acts and their sections of Module C. Now, I have discussed them just in brief so that you can know which acts are important. If you want to revise in detail all of these acts, then you can join us in the capsule batches. This is the CAIIB June 2025 all in one capsule batch. So all your four papers will be covered here: ABM, BFM, ABFM, as well as BRBL, both in bilingual as well as English medium. Separately, you will have your English medium capsule batch, which will be your best last minute revision strategy. So 50 plus hours of live marathon sessions, subject wise revision, and class notes. And then you will also have tests for your elective papers. So enroll now and start your revision. And other option is simply you can join the Super Elite plan, where apart from the capsule batch, you're also going to get access to your foundation, master batches, elective paper foundation courses, everything. So that is all for today. I hope this session was useful. I will also bring the module D for you. We will cover the acts there as well. And all the module A and module B acts have also been covered. These videos are present on YouTube, and daily we are bringing these important series and discussions for you. So don't forget to subscribe to our Oliveboard JIB CIB English Medium channel. Like the video, share it, and I will see you in the next important sessions. Thank you and all the best.